is David Greene. I'm the Senior Trust Officer at First Covenant Trust and Advisors. And today we're going to be talking about the basics of estate planning. What does the term estate planning mean? What are some of the tools that we use to in our estate planning? How does it work? And what are some considerations that we need to think about as we're engaging in estate planning? So the definition of estate planning, that if you Google estate planning and find out what the definition is, Wikipedia says it's the process of anticipating and arranging during a person's life for the management and disposal of that person's estate during the person's life and at and after death, while minimizing gift, estate, generation skipping transfer, and income tax. I think that's a pretty good definition. One of the things that the questions that definition doesn't answer, right, is what is an estate? Right, it talks about management and disposal of a person's estate during the person's life and at and after death. So one of the challenges when we're talking about really anything technical, which estate planning and some of the legalese that you get into, some of those challenges that they bring are terminology based. You know, in my world, when someone says the term estate, it can have two different meanings, okay? One meaning is the more kind of broad meaning that's probably more common, and the short version of that is an estate is everything that somebody has, right? That's all of your clothes and all your furniture, your silverware, your vehicles, your real estate, your life insurance, the money at the bank, your investment accounts, your IRAs, 401ks, interests in a business, your jewelry, all that sort of stuff is your estate. Everything that you've got is your estate. Closely related to that is the idea of a taxable estate. Okay, so a taxable estate is, under the tax code, what does the IRS treat me as owning for purposes of taxing my estate? Okay, and I'll talk about estate tax later and kind of how the basics of that work and some of the things that you need to know when you're thinking about estate planning for transfer taxes, which is in this Wikipedia definition, the gift, generation, skipping, transfer, and estate taxes. That's kind of one concept of what an estate is. Sometimes a slightly narrower definition of estate is used, and that is referring specifically to what we call the probate estate. And I'll talk about probate a little more in a little while, but really when you're talking about a probate estate, it's only that portion of your overall estate that the probate court has jurisdiction over, right? And as we'll see in a little while, it does not include things like life insurance, assuming life insurance had a beneficiary designation on it. It wouldn't include things like an interest in jointly owned real estate, right? Because once I die, that's not mine anymore. The court's not going to oversee that as part of the probate process. So I'll get into that a little more, but if we're going to talk about estate planning, I think it's important for us to have a good idea of what an estate is. One of the things I think is important to think about, and we'll emphasize this as we go on, and I think this Wikipedia definition kind of encapsulates some of this, is that it talks about arranging during a person's life for the management and disposal of the estate during the person's life, as well as at and after death. So that's an aspect of estate planning that isn't the first thing that people think of when we think of estate planning. We don't think of planning for, how do I manage my estate during my life, right? That's what we're doing. We're living our lives, we're managing our stuff, we're making decisions about spending and investing and gifting and all these sorts of things that we don't really think of that as estate planning. And in a non-technical sense, it's not. I think when we talk about estate planning and we're talking about during lifetime, probably what we're thinking about is, what happens if I am not able to take care of my own things for my own benefit, even though I'm still alive, right? And so for younger people, the statistical probability is greater that there will be a disability for an extended period of time than an early death, right? So some sort of medical condition, some kind of accident could lead to permanent loss of capacity, but still a long life expectancy to go on. In older folks, some of the things that we think about are the diminishing capacity, right? Alzheimer's and dementia, and those sorts of things, right? Impairing a person's cognitive ability, but their body is still, they're healthy as a horse. They just can't remember that they saw you 5 minutes ago and had the same conversation that you're having again. So in that instance, a lot of times those people need help from someone to manage their things for their benefit, right? In the case of the diminished capacity, the person needs help to remember that taxes are due on April the 15th. They need to remember that their utility bills, right, that check for the water needs to be paid every month, or somebody's going to come turn the water off, right, keeping the lights on, especially the less frequent things like, property taxes that are due once a year, things like that, where it's estate planning, right? We're managing this estate for somebody, but it's during life. So I think that's an important aspect that needs to be emphasized and dealt with as part of the estate planning process. I think that becomes especially significant if if part of that estate, right, is management of a small business. But are there people in place that have the wherewithal, right, the know-how and the legal authority to continue that business if some, tragedy befalls you, the owner, right? Do you have partners? Do you have employees? Do you have family members that, again, know what to do and then have the legal authority to carry that knowledge out and continue the business on? Especially if it's a significant portion of the family's, economic activity, right? If this is just a little side hustle and you're, selling some handicrafts on Etsy and it's a little extra, that's one thing. If this is the business that is the livelihood of your family, then it's important for these things to be in place. One of the things that the Wikipedia definition emphasizes is tax minimization, right? And I think that's an important driver, because that can be a huge impact on an estate depending on the circumstances, whether that's from the income tax side or from the transfer tax side. We want to make sure that the transfer of wealth, however it's done, is tax efficient. One of the things that the Wikipedia definition I think missed is minimization of expenses other than taxes, right? That could be things like court costs, probate fees. If estate planning is done well, it minimizes the possibility or the likelihood, right? There's always a possibility, but it minimizes the likelihood of family disagreements or estate litigation, right? And if that happens, that's a huge cost to your estate, both in terms of dollars and in terms of the impact on the people that are involved. If you've got family that are at loggerheads with one another and are asking a judge to mediate the dispute, it's probably not a smooth process, right? And no amount of estate planning can completely eliminate the human element, but good planning can resolve ambiguities that sometimes lead to the conflicts that lead to litigation. So, an ounce of prevention is worth a pound of cure. The other thing is if there are kind of seeds of distrust, or there's the sibling rivalries that have escalated into, if not outward hostility, kind of some of the under the surface family tension, right? So if we know those things are out there, then we can go the extra mile, right, and make certain that to the extent we're able, the impetus for family disagreement is minimized. So even in the best of circumstances, right, where the family gets along and that aspect of things is fine, an important element of estate planning is easing the burden on those people that are left behind after a loved one dies, right? And if the estate planning process was thorough and up to date, then the post-mortem process of transitioning into kind of a new era for the family is going to be smoother. And so the psychological burden of dealing with the loss and dealing with all of the stuff that goes along from a just business and legal and paperwork and organizational perspective, right? If that's smoother, then the impact on your beneficiaries is lessened, and the focus can just be on mourning and grieving. So one of the other benefits that Wikipedia doesn't really talk about is, the potential for protecting beneficiaries, right? And I'll talk about that a little more later. We've talked about maybe some of the psychological impact being not eliminated, but lessened. So some of the tools that we use to do estate planning, right? And I'm just talking about 101 level things here. This is stuff that everybody who is age 18 or older ought to have. And then there's some more advanced stuff depending on your circumstances, the assets that you're dealing with, certainly the size of your estate, right, in terms of estate taxes and family dynamics. So there are other things that are out there. This is certainly not an exhaustive, it's not intended to be exhaustive list of all the things that are out there, but an introduction to the basics and what we need. So kind of thinking through a timeline here. We're alive, we're well, everything's fine, we're taking care of ourselves, our own business assets, paying the bills, signing the tax return, all those sorts of things that go along with managing your own life, right? And as we go forward, we're going to go to a period of potential disability, and we'll talk about, if that hypothetical possibility becomes reality, what plans do we need to have in place for that? Eventually, we'll come to that point in time where, as Shakespeare said, we'll shuffle off this mortal coil. What happens at that point going forward, and how do we transition from, this stuff being ours to, the next generation or whomever our beneficiaries are? So during life, one of the tools that we use is a durable general power of attorney. And what a durable general power of attorney does is it is a legal document where you delegate to someone else your authority to do things. Okay, so some of the different flavors of that are, in a general power of attorney, typically that's designed to be very broad, right? A lot of these things say anything that I could do legally with my stuff, I am empowering this other person to do that in my stead. That other person is sometimes called an agent, sometimes called an attorney in fact. So two different words for the same thing, but that's the person that is acting on behalf of a principal, right? And this is going back to some of that terminology. The principal is the person who executes the power of attorney and delegates the authority. The agent is the person that exercises the authority on behalf of someone else. That agent, right, the attorney in fact, is a fiduciary, which just means that they have a duty in the law to act in the best interests of that principal. Okay, and we'll talk about fiduciaries throughout this estate planning basics talk, because a lot of the jobs that need to happen in a fiduciary capacity. And that's what First Covenant does, is we're a professional fiduciary. So we serve as agent under power of attorney to do the things that people need done. A couple of different kinds of powers of attorney. One is called general, and I just talked about that. That's where the powers that are delegated are very broad. The other side of that coin is a limited power of attorney. That may be limited in terms of time, right? Think of young parents who are taking a second honeymoon, and they've got a couple little kids that they're leaving with grandma and grandpa, and they want those grandparents to be able to make decisions for the children while they're gone, right? They may give a power of attorney for the care and decision making over the children for the next 2 weeks, while they're vacationing in Europe. That would be limited in terms of time. As a business owner, right, there may be things that only you are legally empowered to do, but you may want to take that vacation in Europe, and you need to empower some person to do the business owner sort of things while you're gone. That can be limited by time, or it could be limited in scope, right? I'm delegating my authority to, sign leases, for example. And any lease that I could sign and bind, myself, I'm empowering this other person to do that. So they could be limited, or they could be general. Another kind of distinction or two different types is immediate versus springing. Today, and some people might argue about this, but today I'm alive and competent. I can enter into legal agreements on my, for my own behalf. I can sign binding contracts and that sort of thing. But it may be convenient for me, right, to have someone else authorized to do those things on my behalf. I may want someone else to have access to my checkbook to pay my bills on my behalf. I may want someone to be able to go out to, a property auction and decide whether or not to bid, and, if the price is right, to purchase a property for me. All right, and I might send them out there to do that, even though I've got capacity to do that myself. It's not that I can't, it's that I'm leveraging my authority and delegating it to somebody else so that they can exercise authority on my behalf. That's immediate. A springing one is a flavor of this that we're often using in estate planning, and that's one where, hey, I've got capacity today. I can do what needs to be done for myself today, but what happens when I don't? Right? What if I get in that car accident? Or what if I have that stroke? Or what if I have this disease that starts impacting the ability of, my brain to make decisions? And in that case, if I cross over the line from competent to incompetent, right? And sometimes that's not especially clear where that line is, but assuming that I do, I want someone to then have that authority spring to life, which is why it's called a springing power of attorney, right? I don't want them to have that today because I kind of want to keep control over my own things. I don't want anybody to interfere with that, but I do want to have a backup plan in case my capacity is diminished. And so I want somebody waiting in the wings, whether that's a child or a sibling or a professional like First Covenant, to be able to exercise that authority and take care of the bills and the management of things, including potentially a business. So one of the things that we also think about that's similar in concept, although the subject matter is different, is a power of attorney for healthcare, or an advanced directive. And again, that's the same thing. As long as I'm competent and can talk to the physicians and the doctors about, do I want to take this medicine right, and accept the side effects, or would I, decide not to? Do I want to have this surgery or do this treatment or go through this diagnostic test, or do I not? And as long as I'm competent to make those decisions after hearing from the medical people, the pros and cons and the risks and the benefits, I can decide that for myself. But if I have that diminished capacity and I don't have the cognitive ability to give informed consent about my own care to the physicians, I want to have someone that has been delegated my authority, hopefully, right, when we're doing this planning, someone that I know knows my preferences, kind of my worldview, my outlook on things, that can then make those decisions about, what risks are worth taking. And that could be anything as, mundane as the medications that I'm taking for blood pressure, to anything as dramatic as, hey, we were going in the middle of surgery to excise this tumor. Turns out it's gotten inside the spinal cord, and if we keep going, there's a significant possibility or risk that David will be paralyzed if we do this. If we do nothing, right, or if we stop here, the tumor will still be in there because it's down in the spinal cord, and he may live a little bit longer. But what are those risks and benefits, right? That's dramatic. And if I'm asleep on the surgery table, somebody needs to be able to make that decision. All the way to the end of life scenario where, medically speaking, I'm not expected to recover, but the medical technology is such that my body can be kept alive for a long time. What do we want to try? What do we want to not try? Right? How long do we want to give this miracle to happen? Right? And so we're putting that authority in the hands of others to make those decisions on my behalf. One other possibility, or one other tool that we sometimes use that has impact during life, is a revocable living trust. And the way the revocable living trust works is that it's a legal document, but if you think of it as the treasure chest, you put your assets into this container during your lifetime, and you're the one that has the keys to the kingdom. You're the one who's managing this stuff. You take stuff in and out of it. You do with it what you need to do. You invest it. You're making decisions. But there's a successor trustee who's waiting in the wings, that if you become incapacitated and you're no longer able to serve in the role of the trustee, right, for yourself with these trust assets that you've placed in trust for yourself, that your successor trustee can then step right up, kind of pick up that ball where you left off and keep moving down the road, paying the bills and doing things. It's similar in effect to a power of attorney, but it can actually be more powerful because the trustee, right, again, in a fiduciary role, if this is my trust with the assets that I've put in there, and my sibling is now the trustee because I'm disabled, or my spouse is now the trustee because I'm disabled, there's a fiduciary duty there. So they actually own the assets for the benefit of the beneficiaries of the trust, and while I'm alive, that's me. But because they're the legal owners of the trust, they're the trustee, they can go in and they can write checks out of the checking account. They can go in and rebalance the portfolio because we need to be more conservative in investments now that I'm not earning an income because of this disability, or whatever the case may be. They've got that authority to act on behalf of those assets. So sometimes a revocable living trust can be a good tool to use for lifetime estate planning. The more classic example of what estate planning means is a will, right? That's what everybody thinks when they think estate planning. They think, I need to have my will done. And the will does what the stereotype says it does. It dictates what happens to my assets after I die. There's a statute in every state that says what the estate plan is if someone doesn't have a will and dies. But if you want to be, if you want to engage in planning and have a say-so about who inherits from you, then the will is the way the law provides for you to make those choices for yourself rather than kind of having the default estate plan that the legislature has laid out. In Tennessee, if you're married with no children, your spouse is your heir. An heir is one of those legal jargon type terms that people throw around and sometimes not very precisely. An heir is someone who inherits from you if you don't have a will. So that's called intestacy, right? Testate is the condition of dying with a will. Intestate is the condition of dying without a will. And that's sometimes why a person who makes a will is called a testator. Right? If you think about all those things in the context of the phrase last will and testament, right? Somebody who gives a testament is a testator. Someone who has that is testate. Someone who does not is intestate. The will provides for what happens to my stuff after I'm gone. Another important function of that will is nomination of guardian for minor children. So if you've got children who are under the age of 18, both of their parents are incapacitated or are deceased, we need to name guardians to be appointed for the care of the children. And a will is a good place to nominate guardians for children. The final decision, right, is the court's. There may have been some intervening instances where the person that you've named as the guardian under your will, maybe they've predeceased or they're incapacitated or they're incarcerated at this point or whatever the case may be, that they may not be a good choice. But in general, courts give, unless there's a real good reason not to, the courts are going to give a lot of weight to the nomination that parents make in their wills. Sometimes it makes sense to do this after death or post-mortem estate planning through the use of that revocable trust that I talked about before. Right? So in this timeline, we've gone to the point of death. And I think one of the things that we need to understand before we can appreciate the value that the revocable trust has in managing things after a death is, how does property actually pass at death? And so understanding what the probate process is. And I alluded to this a little bit earlier when I was talking about the definition of an estate versus a probate estate. So out on our website is a longer version of this explanation about probate. But for our purposes here, when we think about how property passes when someone dies, I think of it as three major categories. Number one is, what did I have that was jointly owned? Okay, so if my house is owned in my name joint with my spouse, and then I pass away, she owns it all, and we don't have to get lawyers involved, we don't have to get probate involved. It's just the moment after my death, she's the 100% owner of the home. And that could be the same for a joint bank account. Right? Anything that you've got, a vehicle, anything that you've got that's joint, when one owner dies, the surviving owner owns it. Now, that's a little oversimplified, but in general, if you've got right of survivorship assets, the survivor inherits by operation of law without further work. The second major category is contracts. The big pieces in this category that I think of are your life insurance, right? Your life insurance while you're alive generally it's just a contract with a company that upon proof of your death, that company is going to pay your beneficiary some amount of money, right? And that's the contract. And the contract says who is going to receive the benefit of the life insurance after your death. That's a beneficiary designation that you can change, but it doesn't have anything to do with who your beneficiaries under your will are. The person that inherits from you under your life insurance contract, it doesn't matter. I could say everything in my will, I'm leaving to the Beach Boys, but my life insurance says my spouse is the beneficiary. That life insurance company's not even going to they're not even going to know anything about my will. They're just going to say, okay, spouse is the beneficiary. As soon as she sends in the death certificate and the claim form, she's getting the proceeds of that. Same thing with a retirement account, right? 401k, IRA. Typically those have beneficiary designations on them. Sometimes people will add beneficiary designations to bank accounts or brokerage accounts, pay on death or transfer on death designations. They act in a similar sort of way. Pretty much everything else that I own is going to be subject to probate and under the control of my will. Joint property, that passes to the joint owner. Life insurance, retirement accounts, things like that are going to pass to the beneficiaries who are designated. All other property that's owned by me is going to be owned solely, and it's going to be subject to the process of the probate court, right? And that's going to be my probate estate. The probate estate is overseen by the court. The terms of the will are enforced. Creditors are paid. And then at the end of that process, beneficiaries receive their inheritance. In Tennessee, the probate process is relatively simple, relatively straightforward, fairly inexpensive. There are some jurisdictions where those things are not true. Virginia, it's less straightforward, it's more expensive, and it's more time consuming, right? So how important it is to avoid probate depends on the circumstances. One of the telltale signs is, do I have real estate or property in multiple jurisdictions? Maybe Tennessee is not worth going through the trouble to avoid probate. But I also have, real estate in Virginia and a vacation home in the mountains of North Carolina. And so I've got 3 different states. At that point, it probably becomes important that I utilize some probate avoidance, and a revocable living trust is a good way to do that, where I'll actually fund all those properties into that revocable trust so that I don't have anything in my probate estate, because I don't own anything. Everything is owned by the trust. Right? And the trust, even when I die, the trust doesn't die. It may have provisions in there that say, successor trustee, if I'm dead, here's what to do with my assets. Go do that. I'm not around to do it. The successor trustee carries out those responsibilities in their capacity as a fiduciary on behalf of the beneficiaries that I've named in my revocable trust. And the probate court doesn't have anything to do with it, right? And like I said, in Tennessee, that's an advantage. If you've got property in multiple jurisdictions, that's a big advantage. As a business owner, one of the things that can be important to think about is, does it make sense to avoid probate to preserve privacy? Right? If I have a will and I die, and my executor needs to probate that will because there's some asset or assets that are in that probate estate, right? They can't transfer without putting the will through the probate process. When that will gets to the courthouse, it's a public record. And so my neighbor or my kids or my competitors can go and pull the will and find out who's inheriting from me, under what terms, when, how. Something to think about, right? How important is that privacy to you? With a revocable trust, there is no reason to put the will on record. The trust can be very confidential, right? You can dictate the universe of people that you want to know the terms of that trust. And that may just be the successor trustee. Hey, you read this, you do what it says, you do it on behalf of these people, but they don't need to know what it says. Sometimes that can be good, sometimes that can be bad, right? We talk about family dynamics, right? Sometimes keeping things on a need-to-know basis can kind of help suppress some of that potential for rabble rousing and infighting. Sometimes transparency can be, they talk about sunshine being the greatest disinfectant. Sometimes that can be really helpful, just to put all the cards out on the table and say, open book, nothing to hide here, and here's what the book says, and we're going to play this by the book, and that successor trustee moves on down the road. Thinking about planning, whether you're using a will or whether you're using a revocable trust for your foundational planning, one of the things to think about is, does it make sense to leave an inheritance outright to beneficiaries, or does it make sense to create ongoing trusts for the benefit of beneficiaries into the future? So again, if we think of a trust as this container or this vehicle to own assets, the trustee is the person that has the keys. They've got the instructions in that legal document about what you want them to do with your assets. And then it's up to them in their fiduciary capacity, right, on behalf of the beneficiaries, to do those things that you've instructed them to do, right? And that may, again, during life, it may be pay my bills for my benefit, manage my investments, things like that. After death, it may be distribute this, a third to my children. I think there's a good case to be made that unless an inheritance is small, it ought to be in trust for the benefit of a beneficiary. Okay, so instead of a third to each of my children, let's set up 3 trusts and make equal shares that belong to the trustees of those 3 trusts. There's a lot of reasons that we might do that. My children are young, right? It makes a lot of sense not to give them an outright inheritance because they don't know how to use it. My 9-year-old would probably go buy a Lamborghini or something like that that he can't drive. But we need some trustee to manage that for their benefit until they're able to handle things on their own. If you've got adult beneficiaries who are responsible and can handle things on their own, there's still some benefits for trust inheritance regardless. Two main reasons. One is, I talked about the adult child who is responsible. If the adult child is not responsible, right, then we want someone to manage that inheritance for them. We don't want to disinherit them, but we don't want to turn them loose with, a third of our estate. We want somebody to be there to help them manage that for their benefit going forward so that they have it long term. If we're not protecting the beneficiary from themselves, we might be protecting the beneficiary from outside predators and creditors that they have no control over. And that could be people that they've been involved in a traffic accident with, that could be a future ex-spouse, that could be a business partner, right? And there's some sort of, that could be the bank, if you've guaranteed a loan and then subsequently inherited money. If we keep these assets in trust, it gives a lot of protection for creditors in the future. Other thing that we want to think about is the estate tax benefits that may arise depending on the circumstances. And so I kind of set the stage to talk a little bit about what the estate tax context is today and how it may be shifting. And when I say the estate tax exemption, what I'm talking about is the amount of wealth that one can transfer to the next generation free of any kind of transfer tax. In 2017, in the Tax Cuts and Jobs Act, that legislation doubled the estate tax exemption so that it says $10 million indexed for inflation. So today, as I sit here in August of 2021, we have $11.7 million of exemption from transfer tax. So I can give $11.7 million to whomever I choose and the federal government isn't going to tax me. Now, last year, President Biden was elected, and one of the things that he has talked about, and there is actually Senator Sanders has a bill working its way through the committees in the Senate right now that would not just bring that 11.7 back in half, but back down to the $3.5 million level that it was, back in the first decade of this century. Still not a ton of people that are impacted by that, but that's where we are in terms of the estate tax situation. So that's important for business owners to realize, because if you own your business, right, you may not feel like you have a lot of wealth, but if your business is worth a few $1,000,000 and you've got equity in your house and you've got some money in retirement and you've got a life insurance policy and the estate tax exemption is $3.5 million, there's a decent chance that upon your death you'll have an estate tax bill to pay. Even if you don't, right, and bringing this tax discussion back to the benefits that a trust can have for someone who's inheriting is, if I'm the business owner, right, and between my business and my home equity and my real estate holdings and my 401k and just all my stuff, if my net worth personally is exactly $3.5 million, and then I inherit whatever it is, right, and I'll say that my mom dies and I get $1 million inheritance from her, and her executor writes me a check and says, here you go, David, there's $1 million. Well, all of that inheritance is now subject to estate tax, right, upon my death. If she had instead left that inheritance to me in a trust that was for my benefit, assuming that her estate plan was done carefully and properly, I could have the benefit of that inheritance without it being included in my taxable estate. Again, going back to our definitional discussion earlier, as a business owner, we need to think about how do we deal with disability, the killer D's, right? If you're a baseball fan, you might remember the killer B's. The killer D's in estate planning for business owners are disability, divorce, and death. If you co-own a business with your partner and she becomes divorced, do you want some piece of your business to be owned by that ex-spouse now, right? Because that was a big portion of their wealth. Maybe, maybe not, right? What if your business partner becomes disabled, right? Are you going to be carrying that load alone? Or are there things that she's doing that's going to put a crimp in your style as you go forward in trying to operate the business alone, right? Is that going to be something that you need to purchase that business from her? Think through that sort of scenario and death, right? Do you want to be in business with the children or the widow? Maybe you do, maybe you don't, but you ought to think through that in terms of your business and the people that you're in business with. Think through who can own it and who can't own it. It reminds me of the little old man who was in the hospital and the nurse was there and the family, and it's not looking good, and he says, Junior, I want you to have all of the homes, in Beverly Hills, and daughter, I want you to have all of the commercial properties, downtown, and he says, my wife, I want you to have the vacation homes in along the coast. And the nurse is kind of sitting there thinking, wow, this is pretty wild. I didn't know that he had all this. And the wife looks over at the nurse and rolls her eyes and says, he's got a paper route. So we got to think about who's going to own the business after our death, and hopefully you're not doling that out on your deathbed like this guy was. But think about, do we want the business to purchase your share, right? And that in any event of one of these Ds, is the business going to be able to afford that? And basically the effect of that is everybody else that owns the business increases it's like reverse dilution, increases their pro rata share. Is it okay if members of the family become co-owners? Sometimes those family members can have ownership without having control. So think about whether, right, maybe we still want to pay dividends or make distributions to the family, but they don't have management rights. So something to think about there. Or maybe there's third-party owners that have the ability to come in and purchase that. Think about what the price is going to be. How is that price going to be paid? Is it going to be due right away? Is it going to be due over time? A couple of ways that we can think about setting that price. One is all the owners decide what the business is worth and decide, hey, if I become disabled, or if I'm divorced, or if upon my death, here's what you all need to pay my family for my piece of the business, and they can go take the cash. Partners, you go run the business, and we'll move on that way. That's simple if everybody agrees what the business is worth, and if you're diligent to keep that updated, right? If it's a fast-moving business and the value is changing a lot, or if you're not good at getting together with your partners and deciding on this stuff, what you don't want is to agree that the value of your business is $1 million, and then you go for a decade and really grow it so that the true value is, $5 million, and then somebody dies, and the operating agreement says, well, we said that this business was worth $1 million, and so your half is worth $500,000, even though you've been growing that business for the last 5 years. So be careful about that. One mechanism is to hire a third-party appraiser, right? Which is probably a good way to get pretty close in terms of value. Right? It's a little more involved because you've got to go hire that person and allow them to do their thing. Agreeing on a formula, right? 1 times earnings, or some multiple of EBITDA, or some formula, right? If I die on this date, run this calculation, and there's your price. That's one mechanism that you can use to decide. And another method that a lot of folks use is life insurance, right? So maybe we've agreed that upon my death, my partners are going to pay my estate, or my beneficiaries, $500,000 for my interest in this business. But maybe we don't have, a big fat bank account at the business, because if we did, the business would be worth more. So sometimes people fund their buy-sell agreements with life insurance. Right? I have life insurance on my partner. She has life insurance on me. And if either of us die, we've got the wherewithal to pay for, the now deceased owner's portion of that business. So not a lot of detail there, but some things to think about when you're planning your estate. We'll talk more in a different video about succession planning, and we'll talk more about some of the cool things that we can do with trusts in managing these things and kind of going beyond the basic estate planning thing. So things to think about, basic estate planning. If you've got any questions, if there's a way we can help you, just look over your planning documents that you've got now and make suggestions. We're available to do that, including your operating agreements, buy sells, things like that. So feel free to get in touch with us if you need some just guidance and direction. We've got a good network of folks that we use, attorneys that can help put these things together if you don't have them. So be happy to help you. Look forward to working with you. Appreciate your attention and look forward to working with you soon.